Should we close up?
Good morning. I'm going to go ahead and get started. My name is Margaret Little, and I'm an operations deputy with LA County Superior Court. This is Kathleen Dixon.
You're not on.
I'm not on? I got a green light. I'm on? Am I on? All right, he says good now. My name is Margaret Little. I'm an operations deputy with LA County Superior Court, and with me is Kathleen Dixon, who is an attorney who works for our court. For those of you from California, you might know her as the family law facilitator, which is a title we use in California, particularly for self-help as it relates to child support. But in addition to that, she has a much broader job, and she oversees our self-help services for our entire court in a number of litigation areas. We're going to be talking about educational self-help and talking a bit about multicultural community. We're going to use this term a little bit differently than ethnicity per se, or even language per se. We're going to talk about the culture of your court and their priorities in terms of self-help, and even more importantly, about the cultural differences, if you will, among litigation types. The context within different litigation types are practiced, and how that affects self-help. So each litigation area having a little different focus and how that affects what self-help services you might be offering. We're going to try to convince you that integrating self-help, educational self-help specifically, as a core component of the court is the court of the future. And Kathleen and I not only believe in that very strongly, we also walk that talk. Kathleen and I are very much working together as partners in self-help and operations. We work regularly together, as do the operations staff with the rest of Kathleen's staff. We in Los Angeles have a very integrated model of self-help that really integrates it into operations with a real exchange back and forth between self-help and operations. We're going to go over several things today. I'm just going to give you some sort of bullet points on where we're going today. We're going to try to talk a little bit about how educational self-help is integral to the court's key function as an arbiter, a neutral arbiter of justice. We're going to talk about that for a bit, because that is one of the reasons we do self-help in our court, is we believe that is a core part of the court's main mission. We're going to talk about how when self-help is done in conjunction with operations, it actually is a very important resource for the court, and it creates efficiency in case flow management. And finally, we're going to talk about how self-help actually changes litigants' perception of the court, and how important it is to have self-help in your court, because it is more likely to have litigants understand the court process. If they understand the court process, they are much more likely to trust the court process. So we're going to talk about those 3 points.
You want to just click?
Oh, shall I just
go ahead?
That?
So first we want to talk about what is not self-help. It is absolutely not representation. It's not an attorney representing a party, not going into courtroom with them, not handling their case, not making decisions for them. It is not civil Gideon, which, if you're not familiar with that concept, that is the idea that, as in criminal court, an attorney should be appointed for everyone. If they can't afford one, one will be appointed for them. There are, in the state of California now, 8 civil Gideon pilot projects that the state funded, trying out in specific civil areas what impact attorney representation has. It's a very limited scale pilot that is not likely to be extended to every single civil litigant in every single case, just based on economics. And so self-help is not a piece of civil Gideon. It is not representation. It is not even shadow representation. We have some agencies in our area that assist self-represented litigants without becoming attorney of record. And we have, in California, we have the ability to do unbundled, limited scope representation that can include ghostwriting or advising in the background without being attorney of record. That is not self-help either. Self-help is in no way advocacy. It is not doing strategic advice, which is, by the way, spelled wrong there. Thank you. Should be a C on the end there. But self-help does not include giving legal advice, and that means you're not going to be strategizing with one party about how they can gain an advantage over the other party in the course of their case. You're going to share information equally with both sides in the same manner. So what is self-help?
So what is self-help? So I started looking around to see what some of the early definitions of self-help were, and I found this definition from the 1800s, which I keep thinking of self-help as something we sort of invented in the 80s or 90s. Interesting, in one of the early usages, it was in a legal context, and it referred to this doctrine of having a party have the right to use lawful means on their own initiative, and I emphasize on their own initiative, to remedy a wrong. And this was way back from in the 1800s.
A little bit more recent definition following the same concept, that it's providing for oneself without depending upon others. And that's a key piece of what we want to talk about today. It's learning to help yourself, not being dependent upon those who are providing the services.
So then Wikipedia, source of all knowledge, there is this idea of self-help as self-improvement. And interestingly enough, in our culture now, it often has this component of a psychological piece to what self-help is about. Interestingly enough, I think in this day and age, actually, when you look at it in a court context and you look at it in terms of self-help, I suggest that it does still have this psychological component in terms of how the court is perceived by people. So we'll talk a little bit more about that as we go along.
And getting right into what really matters for us, the National Center for State Court website has a very comprehensive definition of a self-help program, which is a service provided to assist self-represented litigants by giving them resources and information that might not otherwise be available to them. And it takes a lot of different delivery models, can qualify as self-help here. The first, of course, being self-help websites. The use of technology can contribute a great deal to self-help if people are able to access it and use it. It's an educational resource. Software programs that are used either online or in your centers that make it easier for people. We use programs that kind of work like TurboTax with very simple questions without looking at a court form, without seeing all those questions that don't apply to you. If you, for example, check off that you do not have minor children, it's not going to ask you the couple of dozen questions related to minor children. It's just going to skip past that and fill out your forms and paperwork for you. Printed handouts, of course, are the basics. But what we like to think about more is the human interaction, whether it's one-on-one working with someone, or whether it's a workshop, a classroom kind of setting, or a clinic where people are working on similar problems at the same time with an educational element included there. Any of these can provide self-help, but we believe firmly that merely assembling your documents, merely using a program that produces the documents for you is not genuinely educational, is not real self-help. So our premise is that in order to provide the greatest benefit to the litigants as well as to the court, you really need to do educational self-help. And we're going to try to convince you that the only real self-help is what we call educational self-help. So why do we educate? Why not just provide mechanical assistance creating those forms? Why bother to teach people about the procedural requirements and to some degree about the legal concept involved in their particular type of case? Why do we bother with that? Our staff would tell you that it's not necessarily the most efficient way. It's easier for me to just fill everything out for them and create beautifully typed documents. It's faster often. even than doing it in a group education. So why do we bother with that? Well, there's a myriad of things that self-represented litigants don't know when they come in. The average self-represented litigant has no idea that they're responsible for moving the case through every single step, let alone that they have to actually write up the judgment. When the judge bangs their gavel and says, "Here's my order," the litigant, just like a professional attorney, is responsible to take note of what the judge says and draft it and have it approved and agreed upon as an accurate statement by the other party, and then the judge signs it. So, you know, the litigant stands there like a deer in headlights while the judgment is being pronounced, and then comes to self-help and says, the judge said I'm supposed to write it up, but I don't know what the judge said. And did we have court reporters present? Did we pay in advance for a court reporter, or does your court still provide court reporters for free? But then are you going to pay for a transcript to find out what the judge said? We want people to go in actually knowing the answers to these questions, so that if they make it to a trial, they know how to put on their evidence, their case, they know what their responsibilities are to take notes and move forward. Let alone all the steps to actually get there. And so these are things that we believe you should be educating people about, that if you don't educate them about the procedures, they're never going to move the case. But more importantly, if you don't educate them about the legal concepts involved, they're not going to understand what's happening. They're not going to understand why decisions are made. And worse, they're not going to understand how to get their side of the story presented in the courtroom.
And so why would that be important, that they be able to present to the court what their issues are, what it is they're asking for from the court, what their evidence is? The most basic responsibility of the court is to determine the rights, to resolve the disputes. And if this is the most basic function of the court, then why would we even be talking about self-help? We'd be talking about self-help because in order for the court to be a neutral arbiter, they have to hear the information from both sides. And if one side is not able to give information on their case, it is impossible for the judge actually to be the neutral arbiter. So it is very important to have our litigants come before the court and actually be able to present their case. They have to know what is relevant to say, and they have to know when to say it in order for them to present their case to the court.
You might notice we keep talking about neutrality. Why is it necessary for the court to act as a neutral arbiter? What if the courts were not seen as neutral by the public? If the average person believed that only the rich would be able to win in court, which when you look at the cost of hiring an attorney to represent you, that's not far from the truth, that only if you can afford a good, competent, expensive attorney do you have the best chance of winning in court. What if people did not trust that the court was fair to everyone? If people really lose their confidence that I'm going to be treated fairly and have an equal chance to get my side heard, if I don't believe that, if a majority of the public believes that they cannot trust the court to treat them fairly, what's the outcome of that for our society? It's the Wild West. If you can't trust the court to be a fair and neutral arbiter of your disputes, you resort to violence to settle disagreements. And it's not just the historic Old West with the gunslingers and John's cowboy hat here to remind us. It happens today everywhere. When we think about this concept, think about gang drive-by shootings. Why does one gang send its members out to retaliate against another gang that has injured someone within their group? Because they don't believe that they're going to call the police and say, hey, red gang has injured somebody in blue gang, we want you to go and prosecute them. They don't believe that the police or the court system is going to treat their gang members fairly. They don't believe that they're going to receive justice and that they're going to be treated with respect and that they can trust that. So they're resorting to violence. It's a very simple carry through from Gunslingers of the West. You're settling it yourself.
So in order for the court to actually move forward with the case, and in order for the court to be able to be the neutral arbiter of justice, and to have the confidence of the litigants in what the judge is doing, the person has to be able to understand how the court system operates. They have to be able to present their case to the court and not have the court process be a mystery to them. That which we don't understand, we tend not to trust. And so in order for us to be able to trust it, for our litigants to be able to trust what it is we're doing in the court, they have to be able to understand it. If you can understand what's happening, you feel far more in control of the decision-making process that happens in the court. So you have to understand what the possibilities are, you have to understand what the possible decisions are for you to make, then you are in control of it and you understand what is happening. If you are in control and you understand, you are far more likely to trust it. I mean, when we think about one of the things people really hate about being in the hospital, aside from the fact that you're sick, is you feel totally out of control. You don't know why people are doing things, people don't explain things to you, things are being done to you, and it's really a pretty awful experience for people generally. Well, when you think about it, the court system can be very similar. It's a complex system. There often in our court system is very little by way of explaining to people what it is that is going to happen to them, therefore it doesn't make sense to them, and I'm sure you've all been in courts and heard people walking down the hall saying, I don't know why the judge did that, it was the dumbest thing, or I don't know why this happened, or they leave the filing window wondering, I don't know why they didn't explain to me what I needed to do, what the forms were, what the possibilities were, and people get very frustrated with it, and understandably so. So it's very, very important that we can have litigants who are engaged and educated users of the court system. Now, judges certainly are a part of this, and I don't want to suggest that self-help is the only part of it. In fact, judges are a very important part of education in our courts. When litigants are sitting in a courtroom and they're watching other matters before the court, they learn a great deal about what the judge is listening to, what the facts are the judge needs to know, what the judge is going to do with that. So judges are, in many ways, providers of self-help services in our court system.
Judges can actually be quite engaged in soliciting information and facts, and this is a chart that was put together by Richard Zorza and John Grecian in 2004 for
A couple of years ago.
for a training that was done as we were developing self-help services. But even before you start adding self-help services, they were looking at what can happen in the courtroom to make it more feasible for a self-represented litigant to have a fair chance to be heard, and pointing out that being passive, for a judge to be passive, does not necessarily make them neutral, and being engaged does not necessarily make them non-neutral. That if you look at the engaged, neutral judge, that's a judge that's creating an environment that is going to allow the parties to bring out their information. Judges can ask questions, they can follow up. When I was in private practice, I was originally kind of taken aback when I would finish presenting my case or examining a witness, and the judge would lean over and ask additional questions. And I was taught as a young attorney that that meant I wasn't doing my job. If I hadn't gotten all of the facts out and the judge felt they had to ask additional questions, I was really embarrassed when I was a baby lawyer and that happened. After a while, I became used to the bench officers that I was appearing in front of and realized that often certain judges, not all, always asked questions. They wanted to ask certain things in a certain way, and that they were looking for information that was important to them, and there's nothing wrong with that, as long as they are neutral in how they solicit that information, whether there's an attorney representing the party or the parties representing themselves. And an engaged judge can really make it far more possible for the judge themselves to hear the story that they need to hear. Similarly, court staff, whether they are in the clerk's office or in the courtroom, can assist people with information. And in California, we actually have a requirement in the Code of Ethics for employees of the court that you must provide accurate information in a timely manner without taking sides. That there used to be signs in our court clerk's offices that said, quoted a statute and said that the clerk of the court is prohibited from practicing law, and for decades and decades and decades, that meant I can't even tell you what forms to use. If you are at a point in your history where there are actually forms, you used to have an attorney draft everything from start to finish, even if it was exactly the same information every time. We created it on a typewriter without a computer on ruled and numbered paper. When many states created forms that make it simpler to get the information out there, you would think that that's a giant step toward helping not only new attorneys know what to do, but for self-represented litigants. But if you walk into the court's office and there would be about a 5-page list of forms by number, not even by title, and not grouped originally in subject matter, and the clerk would point to that list and say, fill out the request and tell me which forms you want. And you might walk in and say, well, I'd like to start a divorce. Well, tell me which forms. It was a major, major step to move toward having packets given to people. But just that concept that the clerk couldn't say, okay, here's the set of forms that you need for that, and hiding behind kind of a belief that the court wasn't allowed to have their clerks practice law, goes back to a misunderstanding of that basic concept.
So given that judges are such an integral part of self-help, and given that in this day and age our court clerk's office, our JAs, are a big part of it, why isn't that enough? Why shouldn't we just stop with that and say we've now done self-help? For one thing, let's face it, a JA really does not have time to answer questions. Can you imagine on a calendar with 80 matters, a JA trying to explain to each person what is going to happen that day in court, or answering even a brief question? At filing windows, when you have long lines waiting, you are not going to be able to take the time to over and over again, and it is over and over again, answer the same question. It just isn't a feasible way to do it. So there's another step we have to take as a court system. There's another step we have to take to integrate this educational component into how we operate as a court system and make it part of our core operation. And for a number of reasons. What's in it for court staff? Okay, a lot. First of all, in the clerk's office, I have to say, I think filing window clerks are like the backbone of the court system. I have such respect for people who can do that all day long. I really do. Because near as I can tell, somebody gets in line and asks them the same question 100 times a day. It's just incredibly repetitive. And I don't understand how they keep their energy going to constantly be so courteous and answer those questions over and over again. I think they're amazing. But if you have some self-help services, some educational self-help services, you can actually then, as a filing window clerk, say, if you go to the 4th floor, there's somebody there who can answer your question for you. And that is such a relief. When we first opened our self-help center in the mosque, I was so relieved to be able to tell somebody who stopped me in the hallway and asked a question, you need to go to the 4th floor, and you need to talk with the self-help center. So it takes a big burden off. Secondly, for the filing window clerks, you're not handling the same document over and over again with the same errors that make it difficult for you to process that document. In our judgment unit, we were processing, in our family law judgment unit, we were processing family law judgments from pro pers 3 and 4 times. The same parties, judgment, reject, judgment, reject, judgment, reject. The amount of staffing time it takes to keep rejecting a document and handling it over and over again is just wasted time. So big advantages for the clerk's office. For courtrooms, obviously it's better to have litigants who come in understanding what's going to happen. The whole hearing goes more smoothly forward, probably takes a lot less time. very helpful. Case flow management, impossible, I believe, to do without an educational component in any area of law where you have a lot of pro pers. You can put all the milestones in you want, all the checkpoints you want, remind people that they have to do X, Y, or Z. If they don't know how to do it, they're not going to do it. So you get very stuck in a cycle in case flow management. In Los Angeles, we've managed to integrate our case flow management process with our self-help services so that we developed them together. It was a collaborative effort. Our self-help attorneys and our operations staff together developed how we were going to do case flow management. When we implemented it, we do it together. There's self-help staff working on it, there's operations staff working on it, side by side. It's very much an integrated process for case flow management.
So now you're going to design a self-help program for your court. And the most important first step is don't just take whatever money is out there with priorities set by someone else. Don't just say, okay, good, here's a grant that has parameters and we're just going to do that. Stop. Before you take the money and sign off on that set of performance measures, assess what your court's priorities are for self-help, and then assess your resources. So when you assess your court priorities, you really need to look at what your court wants out of a self-help program. Not just what your legal aid community wants to provide, and they're not necessarily always at odds, but there are differences, and we've learned from some mistakes in Los Angeles. I think that when we started in self-help, it was kind of a new scary concept to court leadership, to our judicial leadership. The idea that the court might employ attorneys and paralegals to come in and help people through their cases sounded like the court was not going to be neutral. It was kind of a scary concept. And so the initial reaction was give the money to legal aid and provide services that legal aid develop. So those differences, though, in hindsight, have really become kind of glaring for us, and we've been adjusting, going back after the fact and adjusting the way that we provide services. In Los Angeles, we have the benefit of a very rich legal aid community throughout the county and a variety of services that are out there offered by big and small agencies, probably a bigger set of resources than most counties, but every county throughout the country has legal aid provided. And remember when we talked at one of the first slides, I said that self-help is not representation, it's not legal aid. Okay, so when you look at the court's priorities, we want you to look at the community characteristics from the perspective of your court. So we're looking at, this is actually your slide I'm stealing away from you.
You were doing just fine with it. It was okay with me. So Kathleen's been talking about knowing your court's priorities, and that is a very important thing because self-help really has to be a part of what the services are your court is delivering, and not just because you happen to have a self-help provider who decides to provide those services in your courthouse. But also you have to be looking at what the nature of the communities you're dealing with. And I mean ethnicity and language being part of that, but also, for example, how much mobility there is in your community. When we were engaged in providing self-help services in the early days for family law cases, we wanted to have a clinic on how to serve people, how do you fill out your proof of service. And we realized that, oh my goodness, an awful lot of people couldn't serve because they didn't know where somebody was, somebody had moved, so we realized we had to have a workshop on posting and publication because that was the nature of our community. You have to know what the educational level is, and you can't produce a lot of written materials if in fact that is not the way the people in your community are going to be able to consume information. The availability of technology, and certainly not just websites, but apps and other sorts of ways of reaching people that may make more sense, particularly with younger litigants. I mean, they are so far past the internet. They're on to using only their iPhone. and we have to accommodate to that. So these are all things that we have to take into account as we're deciding as a court what our priorities are and then how we're going to deliver those services. So a third piece of this is we looked at priorities, we looked at the nature of our community, now we're looking at different litigation types and the context in which those litigation types are practiced. So these are some key issues that when you look at different litigation types you might think about. Certainly what the focus of the decision is, how complicated it is, how long is that case? Is it a quick case that's going to take a month or 2 months to prosecute, or is it something that's going to last for years? Are people likely to be represented? Is one side going to be represented only? And how much of an understanding of the legal system does someone need in order to operate with that litigation type? So for example, let's look at UDs. A UD decision is essentially a focus on whether you have a defense on habitability or whether you're going to be able to evict somebody. It's a fairly simple decision in many ways that has to be made. Not terribly complicated most of the time. The outcome for the litigants, oh, there's a winner and a loser. There's definitely a winner and a loser. That's how a UD case would be. It's pretty short. So for example, if you were providing self-help services for UD cases and you were offering a workshop once a month, that probably isn't going to work in a UD case because the time frame is so short between when the case begins and the case has to end. So that isn't going to work. In UD cases, usually one side has an attorney, usually one side does not. Just the nature of the cases. How much of the legal system do you have to understand? Not necessarily a whole lot to be able to get through that case. It's a little simpler process. In contrast to this, let's look at family law, and particularly a family law child custody matter. The focus is best interest of the child. Boy, there's an ambiguous concept. Best interest of the child. Often very difficult to define, in part because it has both a legal component and it has a psychosocial component to it. It's a very broad concept. Not only is there the statute you have to consider, there's an awful lot of case law that pertains to child custody matters. So the depth of understanding you have to have of the legal system is pretty broad. We all know family law cases go on forever. I mean, they can last from when a child is born to the child is 18. Long time to be in our court system. And these are the ones that judges kind of refer to as frequent flyers because they can come back to our court system over and over again to relitigate issues. Very importantly, in the affiliation between the parties is they're intimate parties. And that it's an ongoing relationship they're going to have if they have children. So there's not a winner-loser concept, but a concept of maintaining the relationship between the parents as parents, which is a very different sort of outcome focus than the focus simply on a winner and a loser, which is very much discouraged in family law to think about it as a winner and loser in a custody matter. Probably 70 to 80% pro pers. And in terms of their understanding of the legal system, you have people that have attorneys, very high level of attorneys, very sophisticated litigation, and you have a lot of pro pers that really don't understand at all what the decision making is for the judge. So as you can see, just contrasting those two, you would design very different self-help programs for those kind of litigation areas. So in family law, we focus on workshops. It is to our advantage as a court with family law litigants to make sure they understand quite well what the legal parameters of prosecuting a case in family law is about, because they're going to be with us a long time, because just getting them into the system and helping them fill out a petition for divorce is not sufficient to get them out the door. So in family law, we have these extraordinary inventories of people that got started, think they're divorced, remarried 4 times, and never actually turned in a judgment. Definitely to our advantage to train them at the beginning, teach them, educate them about what's involved in a family law case. For that reason, workshops work great in family law. It's a really good way to do it. In UDs, you have to be there every day when people come in because that's the nature of a UD. So you design very different programs. Sorry.
I'm going to stay on this slide for a second.
Yes, ma'am.
So when we began self-help services, both our legal aid community partners who had the initial funding for opening self-help centers and the court, judicial, and operations leadership that looked at priorities, we all agreed that the highest priority for self-help services should be in cases that most impact children, families with children. We talked about the differences between the court's priority and our legal aid partners. Our legal aid partners' highest priority, when they looked at the impact on families, they determined the highest priority being eviction cases, defense in particular of eviction cases, which creates a little challenge about neutrality because we want them to assist both sides equally. So you need to be assisting landlords that maybe are small landlords that can't afford attorneys as well. Just a little side on neutrality, but just looking at the type of case that they chose as their top priority, whereas the court chose family law as our top priority for the cases that most impact children and families. And so as we were developing side-by-side self-help programs, we developed different models that evolved very differently, primarily because of the case type that was involved. So our legal aid partners concentrated very heavily on one-on-one services, having staff or volunteers sit down, one person with one volunteer or staff member, and help them through whatever paperwork was necessary, usually to respond within a very short frame of 5 days to respond to having been served with a notice of eviction. And so not a lot of time for education, just get it done. Get that answer in there to protect yourself from the clock ticking toward a default without you even having a chance. Very different model than in self-help for family law, where we've determined that as Margaret says, we want to invest in educating people about not just the process and the many, many, many steps that they're going to have to go through to complete the initial case or post-judgment modifications later, but also to understand the concept. As Margaret mentioned, the idea that in a custody case, the best interest of the child is the most important underlying goal. So just as an example, when we talk about educational self-help, one of the things that we do in family law is to say, you need to understand that, for example, in California, our forms for custody have a number of boxes that you can check which kind of custody you're seeking. And the last box furthest over is that the other parent will have no contact with the child. The second to last is that they will have only professionally monitored visitation with the child. And an enormous number of people come in and want to check one of those boxes because they're mad, and especially if the other parent has a new partner in their life. They don't want that other woman or that other man around their children. I don't want to be replaced with his girlfriend as the new mom. I don't want them around the children. And so I'm going to check that box that they get no contact whatsoever. One of the things that we do in educational self-help is to teach them what that burden of proof is to attain an order that gives no contact to the other parent. We're going to teach them that they're going to have to present evidence to the judge that it is harmful to the child to have contact with the other parent. That it's not enough to just say, I want this, but that you actually have a burden of proof to go in and convince the court that it's in the best interest of the parent not to have contact. For a litigant to understand the concept that the court is going to be predisposed to prioritize a healthy continuing relationship for the child with each parent, and that if you're going to ask for something other than that, you have the burden of proof to prove why it's in the child's interest, not the adult's. That's part of the kind of an example of the type of thing that we're teaching our litigants, so that one, in the preparation of their initial pleadings, they're not asking for something that they don't have the facts to support, at least most of the time. Sometimes they're still going to check that box. And we have to remember that we're not making the decision for them. We're trying to give them enough education so that they will make decisions that they can support. But sometimes their own emotion is going to say, I'm still going to check that box. And we're going to let them. That's one of the differences between neutral educational self-help and representing somebody. We're going to educate them, but in the end, the decision's theirs. But if they go into court then, and they don't get that order that they've requested, that the other side have no contact, hopefully they're going to at least remember, yeah, they did tell me I was going to have to approve this. And when they come back to us and are saying, why do I have to write up this judgment that gave me not what I was asking for, we're going to review the law with them and explain to them that they still have to put it into the judgment because that's what the judge ordered. But we're also going to be reminding them a little bit about the education, and they're going to perhaps walk away less disappointed, less angry. And there are a lot of studies that show us that if somebody feels they've been heard and they understand the underlying concepts, they're less likely to lose their trust in the court. They're going to have a better experience.
So it doesn't mean that you don't pull on the resources in your community. We talked about some of our legal aid community members having a little different point of view than we do about what is needed in our court by way of self-help. It doesn't mean you don't pull on them. For one thing, they're much better at getting grant money than the courts are. Heaven knows nobody really wants to give a grant to the court that often. So our self-help partners are much more likely to be able to get volunteers, to be able to get funding to do it, and you draw on them. The important thing is to remember that almost all legal aid agencies have a point of view. They are advocates. And so what they are interested in is not necessarily neutrality. So you have to be very careful to stay in control of the services in your building, or otherwise you will not be providing neutral self-help services because they do have a point of view. And they also often eliminate people. So if they can't serve people because of an income level, well, somebody else has to be there to provide services for people who are at a different income level. So if you're not careful, you're going to have a self-help group or self-help services, legal services in your court that are excluding a bunch of people. And honestly, if you're going to be a neutral court, you have to provide for the other people in that area. Otherwise, you're no longer neutral. So you have to be very careful about what you bring into your court, or you find that you're going to be in a position where you're going to be providing services you didn't plan on providing simply to keep the court neutral.
So it's important for the court, whether you're bringing in outside service providers exclusively or whether you're doing, as we have in Los Angeles, kind of a mix of services provided by outside agencies, a number of outside agencies in our case, or whether the court themselves is going to provide all of the services with their employees. It's the court's responsibility. And if you look at any service provided in your courthouse, I don't care what kind of signage that you have, that it's this legal aid agency or the county bar association, whatever kind of signage, whatever kind of disclaimers people sign in hard copies or checking boxes on your website. How many of you read all the way through the disclaimer before you checked the box saying you agreed to the terms of the airline before you got your boarding pass? Not many of us, at least not after many years of doing the same thing, right? So those things that we provide, that we have papers that everybody signs saying that they understand that this is an outside agency, they're not the court, or even if they are the court, you understand we're not representing you. Those are things that we're required to do to protect ourselves, but the average person isn't reading that and digesting that. Anybody who talks to them in the courthouse is the court, especially if they have an official space and they have to wait in line to talk to them. They're going to say, the court told me. It's the court's responsibility to monitor not just the quality but the neutrality of those services. And you have to remain vigilant about that. And we've been doing self-help in Los Angeles now since the year 2000, and in a variety of different programs. And I have staff that I personally train and supervise and write evaluations for, I have to be vigilant with those staff members of my own about making sure that they remain neutral. When I'm coordinating with our legal aid partners, I have to be even more vigilant, and it's even more difficult to make sure that the services are being neutral. And I just want you to think about this a little bit. We're having services that are provided by attorneys or volunteers or staff that are trained and supervised by those attorneys. Providing neutral education is counterintuitive to an attorney. We are taught in law school, first we're taught legalese so that somebody has to hire an attorney to even understand what anybody's talking about. We use all these fancy words which have legitimate purposes. We use these big words to be exact in what we're putting in writing or what we're saying, but it's a whole language that means nothing to the average person. So just learning to speak in normal English or Spanish or whichever language you're providing the services in at a level that people can actually understand what you're talking about is contrary to what we went to law school to learn. But even more importantly, an attorney is taught to take charge of somebody's situation and decide what the best approaches for them are, what the best arguments are, what the best evidence is, to organize that and present it. An attorney's job in private practice is to make decisions for people and to guide their case completely. They just sort of sit there unless you call them as a witness. It's the attorney that's calling all of the shots. So when you turn around and say, okay, now attorney, I want you to provide neutral services, no strategic advice, and don't make the decisions, it's absolutely counterintuitive. And it's just our nature to slip into trying to tell people what they should do. I really want to tell that person not to check the box saying the other parent can't have contact with the children because they don't have the facts to support it. It's a different process to try and educate them so that they understand why that's not the best option for them than for me to decide that. But that slipping into a non-neutral way of providing services is something that is a natural circumstance of having attorneys around, and it's our responsibility to constantly monitor that, retrain, check, and talk about it.
And I would say that we haven't, years into doing self-help, actually fully gotten there, even with our own staff. Our own staff who are attorneys, it's a struggle because that is not the school of thought they come from. But it doesn't mean you shouldn't collaborate, and there doesn't mean there aren't some very successful ways of collaborating. So just very briefly, let me talk about one group we collaborated with in our court and what we learned along the way so that we set this up a little better than we had with some past partnerships. So we had a real need to help people with conservatorships. Wasn't particularly an expertise we had in among our employees who do self-help. So we brought in an agency in Los Angeles named Betzedek to provide legal services. And we brought them in actively because we wanted a service addressing conservatorships. And from the very beginning, instead of putting them off in a room by themselves, we put them in our self-help center. We are actively involved in triaging who comes through to use their services, who doesn't, so we're in control of that. I know it sounds like we're being kind of control freaks, but I think you really have to be very controlling about this. We talked about the kind of service they were going to deliver. Now, I would say, interestingly enough, even though, from my point of view, we were bringing in a very neutral group to help people understand what a conservatorship is and how to apply, I'll tell you what I've learned most recently is everybody doesn't necessarily see that service as neutral. That the very fact that you are actively engaging parties in filing for a conservatorship is hardly a neutral act. And so we are learning something about needing to balance that other side of it, about all the arguments about not so much why you wouldn't get a conservatorship, but what kind of powers you would ask for in a conservatorship. So we're going to have to revisit what we thought was a very neutral sort of service we were providing to look at whether that is truly neutral in the sense of the person who's going to be the conservatee having all their rights defended. So it's a constant going back and looking at what services you're providing and reevaluating them as to whether they're truly neutral. Being neutral actually is a difficult stance to maintain, particularly when you're surrounded by advocates. So one of the things I want to go back and emphasize now, having talked about how you design your self-help program in terms of taking into account what your court's priorities are, what the different sort of litigation areas might need in terms of self-help, and looking at what your community needs are. I want to go back to that definition of self-help that talked about it being a psychological process. Again, one of the struggles that the court has is having people trust in what it is we provide as justice. And unless our litigants understand what we're trying to provide, unless they are good consumers of what we're providing, and they understand it, they are not going to trust us. So I do believe that providing self-help services within the court system is in fact a part of self-help in that sense of helping people to be good consumers and having a psychological impact in terms of trust and confidence in the court. And so I think there is a real payoff for the court in that sense, along with the payoff in terms of the efficiencies that it brings about. So we have talked pretty long, but we have a little time for some questions, if anybody has any.
Not a single question.
Not a single
All right.
question. Okay, so, sorry.
They've asked us to have you use the microphone so that it can record, so I'm going to turn that on and give it to you.
Testing. Am I working? Okay.
Yes.
It's my understanding that in California, the self-help programs are not allowed actually to help clients who are represented. And I was wondering how, being in a program that works every day with family law clients, we know that there's this change that occurs, and John has talked about it yesterday, where you have a client who's represented one day and not represented the next, and they may go back and get represented again. So I'm wondering how you deal with that as you're offering self-help. You don't want to turn people away, and yet I understand it's not allowed. You're not allowed to help represented clients.
Right. We actually have a rule of court that governs the operation of self-help centers in trial courts in California, and a set of guidelines and ethics that go along with that. And we are, in fact, prohibited from providing self-help assistance to someone with an attorney of record, other than in educating them about the process of removing an attorney of record. We can show them how to file a motion to remove, or more commonly, how to file a substitution of attorney form where they've both agreed that the case is now going to be self-represented. But beyond that, we are extremely careful not to step into a case that has an attorney of record. We often have someone come in who says, but I haven't talked to that attorney in months. They don't return my calls. They're saying I owe them money, and they won't answer my questions until I pay up the bill and I don't have the money. And that's a very slippery area for us. We will not provide them with direct services until that attorney is removed as attorney of record. We will assist them to accomplish that, but it was the beginnings of self-help. The private bar was very much afraid that we were going to take away their business. And although in I think every state that has a vibrant self-help program, the private bar has now learned to embrace it. We like to say that the majority of the folks who initially came into self-help really couldn't afford attorneys, and those who could afford attorneys but still choose to go through self-help are the clients that no attorney wants. And in many cases, they've been through 5 attorneys already, and they've got a file like this. And believe me, our staff takes a deep breath and says, oh, I wish they still had that attorney, especially if they've created all sorts of motions and discovery schedules and things that are beyond the scope of what we're really prepared to assist them with, but they now have a case that's really out of control. Those are nobody's favorite litigants. And we're very careful, by the way, not to ever call them clients. We don't want them to believe that they are our clients, that we're going to represent them. And we tell them up front that we're going to help the other side, and we're going to help either side as long as they're not represented. But we're very careful.
That was a very good question and a good point. I think maybe one more. Yeah.
We have the same issue in our circuit, mainly in family law in reopen cases. We have clients that come in, they hire an attorney to file a petition for modification. And then throughout that proceeding, they have a motion for contempt, motion to compel. And sometimes the attorneys actually encourage them to save money, you can file that on your own.
Sure.
And then we are stuck in between, you know, how we can help them because they have some items that are pending that are represented, and there are some things that they don't understand how to deal with that, but they're representing themselves.
Right. It's very tricky, but I think that makes a very good point in terms of working with your bar, because actually I think it makes a lot of sense for attorneys to say, you know, you're filing your petition, you're at very early stages, you can actually go to self-help and move your case along. When it gets to litigation is when you really need an attorney, and often people have run out by then. So in fact, I think there is not really a competition between the bar and self-help. It actually can be a way of full service all the way through, with people spending their money more for what they need. But it is tricky to make sure you're not stepping on an attorney's toes. So I think on that note, I'm going to end because it is time for us to end. I wish you all safe travels, and thank you very much.